speakers I'm going to introduce in a few minutes, and it seemed to us that it was a right time for us to have this conversation, and we're delighted that it's taking place in the time of the year that the French Foreign Ministry dedicates to Latin America, the Semaine de l'Amérique latine. So we're grateful to the French Foreign Ministry for supporting us today and relaying this initiative through the Semaine de l'Amérique latine. So maybe just a few words. You all obviously have access to their bios online, but a few words regarding our speakers here today. First, from Brazil, we have Fabyola, who is with Demarest. Fabyola is a partner in corporate investigations at Demarest with focus on white-collar crime and compliance. She has given countless numbers of seminars and advised multinational and Brazilian groups, boards, executive committees. She's a regular lecturer on really the whole scope of criminal liability and exposure, from corruption to the environment, money laundering, insider trading, and so on and so forth. And I'm delighted to have Fabyola, who's also a francophone and francophile, so that's also nice. To have her on board. Pamela. Pamela is joining us from Colombia. Pamela is a partner at PPU. She's an expert in criminal law and compliance. She's an attorney and consultant in criminal law, corporate criminal law, corruption, crime prevention, and compliance. She has an outstanding reputation in managing crises that stem out of criminal exposure of her clients, and also is a great advisor to decision makers, boards, and executive committees. Then we have moved to Argentina. Francisco, thank you so much for joining us today. Francisco is a senior associate at Beccar Varela. He specializes in ethics and compliance, anti-money laundering laws, regulations. He assists clients with compliance program design, development, implementation, and he has extensive experience in local and cross-border internal investigations. And last but not least, Dantón. Dantón, welcome, who's joined us from Mexico, and he's a leading lawyer in corporate investigations, anti-corruption, criminal litigation, and compliance in Mexico. And as well as the other speakers here today, he has extensive experience advising both domestic and global or foreign companies with local issues and cross-border issues which pertain to our field. So it's great to have you here on board as well. So we thought it would be a good idea to have this conversation and keep it as a sort of an open conversation with practical experience from our speakers, rather than give you a lecture on the law. What we're seeing regularly from a French perspective is an increased cooperation amongst enforcement authorities. Of course, in France, we have the French National Financial Prosecutor, and we'll hear from the enforcement authorities in our jurisdictions here today. But there's an astounding cooperation from the French authorities with European authorities, with Southern American, Latin American authorities, the US, of course, and compliance obligations have become sometimes a lifeline of many of our cross-border companies and organizations, and they are not something that anyone wants to joke with anymore. So it's really an issue of assessing the situation in a given jurisdiction, and as part of assessing the situation, there will be consideration given to potential legal exposure. And I would say that the expectations from local authorities and local businesses when it comes to business practices that we that the large groups don't want to deal with anymore. So that's just a short introduction, but with no further ado, I will put my first question to Pamela. Pamela, if you don't mind, could you just shed a light on some of how Colombia is tackling corporate corruption today, and over the last period?
Thank you, Stefan, and thank you for inviting me here with my colleagues that I respect all. And well, first of all, I think Colombia, like other Latin American countries represented by my colleague here today, has long been dedicated to combating public corruption. But since, I will say, 2010, we had some changes in our legislation and our regulations because we really wanted to join the OECD. So as we wanted to join the OECD asked us to do some changes, and we start doing some changes related with private corruption and with companies that are involved in corruptions. So even though we don't have right now criminal liability for companies in Colombia, we do have a really strong set of regulations that could end in sanctions, monetary fine sanction, disbarment for public contracting with the state, with Colombian state, for companies involved in corruption, even though they are public corruption or private corruption. I will say that maybe as in other countries, obviously, maybe as Brazil, but Lavallato and Odebrecht, they were a milestone in Colombia for companies that are involved. Because I think that are involved in corruption. Because first of all, the regulator began to work harder with other authorities like the DOJ in the US. Also, I will say more recently, 𝐿RBOS was also one of those cases where our authorities cooperated with France, with the Parquet National Financier, in pursuing all these companies that were involved. So things are changing in Colombia. Maybe they are changing slowly, but we have a lot of regulations related to prevent corruption in companies, cooperate more with other authorities and other jurisdictions, and we are trying to be at the same level of other regulations in other jurisdictions. So I think this will be a summary of how are we working. We do have some, different authorities that are involved on this kind of corruption related with companies. So the first one will be the Attorney General's office for the criminal perspective. And the other one are these regulators that are called in Colombia superintendencies. And we have different superintendencies. It depends on the sector in which companies are, their economic activities. So for the administrative sanctions, because as I explained before, we don't have criminal liability for companies, but we do have sanctions, really strong sanctions. So for those administrative process, the regulator will be the superintendencies in Colombia.
This is really interesting because you've shown a path through the OECD, influencing legislation. And France has certainly been in that position. So I can see how the paths are very much comparable. If I may, one question, because you mentioned, I understand the federal prosecutor on one side and the different sort of authorities. Is it your sense that a company with a concern in Colombia would have one person to go to, or with sufficient authority, or does it have that you have to go to 1, 2, 3, 4, 5 people, which is maybe a deterrent to some extent?
Well, at least you have to go to two authorities. So if something happens related with corruption, you will have to deal with the Attorney General's office. So that will be the prosecutors here in Colombia. So for all the criminal matters and the personal and individual liability. So that will be one of the authorities, but the other one will be the superintendency of company. That is the authority that will begin any administrative procedure against the company itself.
Okay.
So, and then it's a little bit tricky because 2 years ago we enacted a new law, 2195 law, that says that for other kind of corruption that is not related with transnational bribery, so that will be internal corruption and some crimes against the economic order, for example, or the financial crimes. So other superintendency of company, other superintendencies of the regulator will be the one who begins these investigations against companies. So at the end, every company needs to know which regulator they have to go, and that will be the one that is that inspects or vigilates that company.
Okay. Definitely need help in Colombia, given the number of people you need to speak to. But thank you so much. It's really interesting to see that you don't have the corporate criminal liability, but you have all these administrative bodies that you have to deal with, and it sounds like a strong need for coordination. But thanks so much, Pamela. So Fabyola, let's move to Brazil. We know the big names because they have made the enforcement of authority in Brazil famous. How has that impacted? How has that changed the legal framework? How Brazilian authorities work? And is this a story of the past, or is it still coming?
Thank you, Stefan. Thank you for the invitation. Thank you for the other panelists to join. This is a super nice topic and the right moment to discuss. So Pamela, thank you for mentioning some similar things that happened also here in Brazil. So the last decade, Stefan, we changed almost everything. So we saw that the criminal lawyers, we are just help clients when they have specific problems. And now the criminal lawyers joined with the compliance lawyers, which is a new area in Brazil that all companies started, and we are in the middle of the business. So we are in the desk of the M&A discussions, which for us it's quite new, but it's really, really important. And the decade, we saw here in Brazil the two important laws that was enacted. First one, the Brazilian Clean Company Act, that similar that mentioned from Pamela. The legal entities now can be also can receive civil liabilities, can be punished by corruption. So we don't have yet in terms of criminal, but we have in terms of civil. And this changed the scenario. Why? Because the other law was the criminal organization. So these two laws we have, and I will just mention two important points. Multiple authorities. So different than USA that we have the DOJ and SEC. Here in Brazil we have municipality, state, and federal levels. So we have a lot of authorities to present the documents and to confess. And this is the other instrument, that tool that helps a lot by one way. So by one side, it was nice that like a DPA, like a plea guilty. So we present a lot of documents, we confess the crime, and then we mitigate the penalty. And for the legal entities, we have the lenience agreement. So we have a super nice government enforcement that began in 2014. And I will try to share, Stefan, my slide. And if I'm not able, someone can help me. And you can, as I can't see you, maybe you you can just talk if something is wrong.
We can see it. We can see it.
Yeah, okay, but better now. Now it's better.
Much
Okay.
better.
Car wash operation. Everybody knows the name in Brazil, of course. And what is really nice? So I choose some picture. We have a crowded people. So, Stefan, each individual in Brazil was able to talk about criminal discussions, criminal liability, and evidence. Nobody here imagined 10 years ago that, for example, Lula, our actual president, could be in jail. Nobody believed could be in jail. Nobody believes that. So it was something that I remember that each Friday morning, I watched TV around 6 a.m. and say, look, and call friends. Who was the company that will be in jail? Who was the executive that will be in jail today? And I have a list of clients and say, oh my God, oh my God, oh my God, oof, Saturday, again and again. And someone that is really common in Brazil, it was called Japonês da Federal, which is a famous guy that represents a clerk from the chief of police that was on the TV. So we changed a lot. And the numbers we can show. So more than 500 individuals were charged. For Brazil, this is really a new moment. And in terms of international cooperation, we don't see it, so we don't talk about it. At that time, we saw that the public prosecutor in Brazil sent emails, talk. So we are in the spotlight during some nice moment, rewarding collaboration. And this we have a trick. So it was not so nice, but the results are really nice. And in terms of number, you can see it, more than 15 billion reais. So in the pictures, we saw in the pictures, two guys that are talking. They represent the federal public prosecutors here in Brazil. And what is also new, task force. We never saw a task force, which means that the public prosecutors, not only in Curitiba, which I state, but in a federal level, discuss and present evidence. And the judge, and I was there in the beginning of this investigation, oh, please, I need evidence. I don't talk without evidence. Which kind of evidence? In the beginning, just mention. And the newspaper, okay, take notes, and jail, send order to jail. So it was really nice moment. And then, oh, but they made, it was not true. They don't have evidence. They just speak. So in the middle of the investigation, the middle of the phase, because we have around 8 phases of there's a super operation, they start to present some setbacks, huge setbacks. Why? Because on the same moment that the judge and the public prosecutor put a lot of pressure to receive documents and confession, they don't really respect the due of process. So as you can see in the picture, they talk too much. So I will stop to share just to see your faces, Stefan. Why? Because they exchange a lot of WhatsApp messages. I thought this is a gun. It's in Brazil we can call it white gun, because through the mobile phone, they talk more than they can. So they discuss how to do. It doesn't matter exactly the evidence. And based on that, in this middle, we are discussing, the superior courts are discussing to and decided to annul a lot of convictions. So good point. All large and middle size of companies decided and has at this moment a super nice compliance program, compliance team. This part is really important. So for the Brazilian one, and this is what you asked me, now we know that we have a robust legislation. It's really hard, as Pamela mentioned, that when we have evidence, when the client presents us some important documents, wow, we need to choose authority. Which authority you can trust? Why? Because when we present for the administrative level, and we have the same problem here, we have the federal prosecutor, which is the criminal side. So we can protect the company, but not exactly protect all the individuals by one side. So sometimes we need that the authorities made an agreement, and we want to present just one fact and receive one sanction. Could be a huge sanction, but it's one sanction. But we are discussing that. This is my perspective. Positive point. Sorry.
Is it fair to say that this case was sort of opened a new era, but was a time where maybe the due process was not there yet, and that enforcement authorities now have gained from experience, and the courts, the litigation, ongoing litigation, will help tailor what it is you can and can't do. Is that sort of fair to say if we look forward to this? And I love your white gun expression for a phone. I think that's great. But it's a white gun, but then it backfires only, right? It's the type of weapon that's used against you. There was the you may have seen this, the ABA ethics has communicated recommendations for lawyers when it comes to managing client data, which includes the phone. And in the presentation speech, they referred to our cell phones, our smartphones, as a window into the soul, because you do on your smartphone, which you may not, be happy that people know about, and how do you like to have somewhere a window into your soul and your client's soul? So it is your obligation to deal with that. In France, we've not sort of dug that issue yet, but I thought it was an interesting. So the white gun, which is like a boomerang, I will keep also for future reference, if you don't mind.
But that's it. And when the federal police or any administrative authority come to the company, first thing, I'd like to search and seizure mobile phone, and then computers. So this is really what we collect, and the discussion now is how to protect the company in terms of information. And maybe you can discuss information and investigation in the second question, but it's a really nice topic.
Super. Thank you so much. Maybe before I move to Francisco, what are the fundamental changes that have impacted sort of the local legal practice in Argentina over the past sort of decade, especially when it comes to corruption and how you advise your clients?
Yeah, of course. And first of all, thanks, Stefan, for the invitation. Happy to be here and with these amazing practitioners. So there are a lot of points of contact with what Pamela was talking about Colombia. So the past 10 years have definitely shaped the anti-corruption landscape in Argentina. And while there have been improvements to our ABC laws, which generate optimism, I would say that recently that enthusiasm has somewhat wavered. And there are a couple of reasons for that I'll get to in a minute. But so what were the fundamental changes in our legal framework? Well, first and foremost, since 2017, we have a corporate criminal liability law. It punishes certain corruption-related offenses, such as bribery and falsifying books and records. You'll see a lot of similarities to other statutes, such as the American FCPA or the Brazilian Company Clean Act. And since that time, our Anticorruption Office has been very active in issuing guidelines and regulations. What was the trigger back in 2017? Well, similar to Colombia, Argentina wanted to join the OECD, which we didn't, but we did significant efforts to do so. We had signed the OECD Anti-Bribery Convention in the late 90s, and really we never did much about it. So the convention asks that parties take measures to establish liability of legal persons for bribery, and 20 years had passed, and that hadn't been implemented yet in Argentina. But fast forward to 2017, we now have a law that imposes criminal liability, and more importantly, has key issues similar to other jurisdictions, which are a form of negotiated dispute resolution. We call them collaboration agreements, but there are our version of DPAs. And the ability or the possibility actually for companies that have an adequate compliance program to mitigate or be exempt penalties. And similar to other jurisdictions, our anti-corruption office has published guidelines for companies to see what corporate compliance programs should look like. So we have a framework that's very similar. There'll be no surprises there if you're ever having an issue in Argentina. But what happened after all these laws were enacted? So there was definitely a big hype around compliance at that time. There was a new law. The car wash operation was booming in Brazil. The Odebrecht case. We had our own case, which was called the notebook scandal, which wasn't as, I would say, it hadn't that big ramifications because the facts under investigations were prior to our corporate accountability law. So only individuals got prosecuted. But it did cause a lot of companies to develop compliance programs, as enforcement at that time seemed very active. That's a good news. I would say that the baseline in corporate compliance, if you take a look 10 years behind, and now it's very different. Companies that never knew what compliance was now have teams. They have a compliance officer. They have basic understanding of what a compliance program should look like, and that's positive. The market is definitely different, but it is true that I would say headwinds from the pandemic, the economic crisis in Argentina, the lack of local enforcement has in the past years caused compliance efforts to be more limited. Resources are a little bit more stingent. Compliance teams have less money to implement controls. So that has been a challenge, at least with some clients, on how to implement cost-efficient compliance control. And that's been discussion here with a lot of clients. Because the truth is, Argentina still faces a lot of challenges with corruption. Those with knowledge of the country or the region may know that the Fernandez administration, it was the previous administration, implemented a lot of controls in the country for FX control. Basically, we ran out of US dollars. So we put a lot of controls in place to restrict payments abroad or restrict the use of dollars in general. And this has been the source of a lot of headaches for companies, issues with customs, with access to US dollars, which must be authorized by the government, dealing with certain public entities has been problematic. So despite there not being enforcement, at least from a local standpoint, there has definitely been a lot of issues from an ABC perspective, which should cause companies that are working here to keep that in mind. We do now have a new administration, somewhat notorious president called Javier Milei. He's very pro-business, pro-market, but I would say that anti-corruption initiatives are not part of the agenda so far. So the focus is on attractive business, deregularizing the economy, bringing foreign investments, but we haven't seen a lot of talk on anti-corruption. So it's a new government. They've only been in office for 6 months. So this could change, but we're still trying to figure out what his approach to anti-corruption will be. But just to paint a picture on how the landscape is in Argentina right now, to end on a good note, we do have our first DPA under the law. It was entered in 2022. It's still confidential, but recently some information has been disclosed to the public as there's been some individuals being arrested. So there's a lot of discussions whether this was a black swan or a trend that might continue.
I do think it's exciting to see that you actually got to a DPA. As some of you may recall, it took Canada, 7 or 8 years to get to a first DPA, just because of the culture change that you need. And as far as I'm concerned, I think Singapore is one of the, I think only I can think of, Asian jurisdiction that has a DPA system. And I think it was put in place because of Lava Jato, because I was concerned about the money going over there. But they've never used it. And I have had a conversation recently on a matter with a colleague from Singapore, and he thinks it's never going to be used. He says we did it for, basically the expression was, we did it for the Americans. And so how much of it is window dressing of trying to be able to answer the if not us, who that we get from DOJ. But so it's so congrats on that, getting through your system, getting everyone on board. What I am hearing is, so you have all the legislation you need, and the rules are there, and lacking strong enforcement or evidence of such, it's difficult to get the clients to mobilize on these issues. Maybe one word on cross-border approach. I mean, if the regulator or the prosecutor would receive a request, say from France or from any other jurisdiction, would that be welcomed positively? Would that be dealt with? Is it sort of something that it really depends on a case-by-case basis?
I would say that would depend on a case-by-case basis. So my experience with prosecutors here is they still, and this is very different. We don't have a task force as Brazil have with Lava Jato. It really depends on which prosecutor you get stuck with. But there are very different levels of sophistication and knowledge of cross-border investigations and what are the rules and how this operates. So it's really down to a very granular case-to-case basis. But companies with foreign shareholders and that have to worry about French laws or U.S. laws, or those really have more incentives and are the ones more active here in Argentina. And when it comes to compliance.
Loud and clear. Thanks so much. Ms. Dantón, maybe a few words on Mexico.
Yes, and thank you for the invitation, Stefan, and to the Minister of Foreign Affairs. I'm so happy to see my colleagues. It's a great opportunity to talk about what's happening in our countries, even though the anti-corruption community has such close connections that we're always in contact with our Brazilian, French, Argentinian, Colombian friends. It's good to have this face-to-face. And I will say that Mexico will reach the 10th anniversary of our anti-corruption laws that were enacted through a constitutional reform, legal reform to our criminal laws. And we adopted criminal and administrative liabilities for companies. We created a new anti-corruption prosecuting office, which did not have a head of that office until 2018. For the first year of the office, it didn't get any budget. So it's taken some time to staff the office and to reach a point where the DOJ has already congratulated the Anti-Corruption Office for cooperating on a case, Stericycle. There has been no cooperation really on significant matters that the DOJ has settled on its own, like Fresenius and Vitol. But there is an ongoing conversation between the Mexican and the US authorities. Mexico is a paradox. We're top 5 in FCPA cases historically. Cases do not bunch up like in Brazil in a very short period of time, but rather go back all the way back to the 80s. And in this new era of cooperation and enforcement, Mexico has been slow to test the waters and to prosecute companies and individuals for corruption because of this delay in the enactment and the staffing of the anti-corruption prosecuting office. But we're in a point where I think we're not far away from seeing more cooperation with the US. We've had two abnormalities. One is the current presidency of Mexico, which has had a speech, reached the presidency with a speech of fighting corruption, but in practice has done little to fight corruption on the executive branch level. And that is because of the accumulation of power. This president came with over 60% of the popular vote, controlled the legislative, was able through that supermajority to appoint a chief prosecutor, an attorney general of the country that is an ally. So this extraordinary power has given him control of who gets prosecuted and how we go about advancing the implementation of our laws. But on the other side, our vicinity with the US makes us accountable, at least at the corporate level, and vulnerable because we sit next to this giant, and we have international agreements like our free trade agreement that has a chapter on anti-corruption and compliance, and we have a common vision of fighting corruption. We can adopt whatever law we want, but once we adopt it, the countries commit to enforcing those laws. So Canada already has a DPA, and the agreement is to have a level playing field for investments and trade. And I think that with nearshoring and with the great economic forces that bind Mexico as part of North America, we're not far from seeing this happen. Our laws, I like to compare the Mexican case with the French case. The French case, the French enacted anti-corruption changes and laws around 2015, as we did. But they've made such great progress through international cooperation that they have two major cases to show. 𝐿𝐵𝐺, Société Générale, they already have a legislative commission discussing what needs to be fine-tuned and changed in the anti-corruption laws. In Mexico, we're in the same discussion. And about, I think, 3 weeks ago, the International Chamber of Commerce Mexico, of which I am vice president of the Anti-Corruption Commission, together with the IBA, held a non-trial resolutions international conference. And we discussed what needs to be done. I think that's the next step. Mexico doesn't really have a legal basis for reaching settlements on criminal liability. The laws need to be reformed. But we created a group, a working group of which I'm part, that will work together with the chief anti-corruption prosecutor, with the Mexican bar and the ICC to come up with a draft project to identify and solve many of the issues that will be necessary to reach an agreement. Agreements have been reached, but with very weak technical legal basis. So that is something we need to tackle. As Francisco discussed, companies have done their part in adopting ABC programs. On the private sector, I think the international forces and companies that work on different jurisdictions have to step up their game and have compliance programs. But there is little incentive on the legal side and clarity on what is required from a compliance program and what incentives you will receive. We know that it's better to have a good compliance program than not, but the law that adopted criminal liability has that serious flaw in Mexico. It's something we are also working to spell out and to try to correct. And what I can say is that the community of that works in anti-corruption and compliance in Mexico is very strong. It's united. It's vibrant, and we're working together with the prosecutors to try to come up with this fine-tuning of the laws. But we're still, before reaching the 10th anniversary, to show an important case. The two abnormalities I spoke, one has been the Mexican presidency. The second was the Trump presidency, which really disrupted the DOJ in a way that we're still feeling the effects. It takes many years to bring an investigation and a prosecution case to the final line. And we haven't seen cases in areas where we have had major scandals, like the Mexican oil company or other cases. Surprisingly, the DOJ has not yet gotten involved. And I think we need that external element, as the Brazilians can attest. The attention of the United States is critical to bring a case in our countries to the level that really affects some change. I know because my law firm is involved in cases that have a Mexican and a US component, that there are several cases that are creating this communication between the Mexican authorities and the DOJ. And I hope that we can soon show a case. I'm very confident that that will be the case. From the exterior, however, if you ask a normal person that doesn't work in criminal law, in compliance, they will say that nothing is happening, because that's what you see. Probably internationally, that is even the same case, that it's a widespread opinion. But I'm sure, because of my personal contact and experience, that we're close to seeing the cases that we've been waiting for. It takes time for legislation to mature, to be digested by lawyers, courts, prosecutors. And I think that's what has happened in the last decade.
Thanks so much. I like the fact that you've stressed the number of stakeholders that need to be aligned for this to work. And we've heard about the private sector. You've mentioned that the private sector maybe has done its part. I also like the fact that it's not because you have the right legislation that is going to work, and it takes the proper legal texts, and we've seen the limits of that, as Fabyola described, also in Brazil. But it takes also the people and the political will, and it's just so important that you can spend the time working with others from the private sector, the prosecutor's office, and other authorities, and speaking at webinars like this and conferences like the one you described of the ICC. I think that's wonderful. So thanks so much for your perspective there. We are halfway through our time, and I'm grateful to everyone. I do hope I can throw another couple of questions to each one of you. So if it's okay, let's try and keep it within 5 minutes. That way we can really go around, and we could go on for the rest of the afternoon for me and the rest of the day for you. But maybe let's move forward and hopefully have a bit of time at the end for Q&A. So let's move to Colombia, and of course we'll speak about self-reporting down the road, and that's something that you mentioned for Mexico, which is very interesting. When it comes to Colombia, Pamela, if we move from corruption to the private sector, as it was described by Dantón, and compliance, what should be expected of international companies that have operations in Colombia?
I wanted to say something. I'm so sorry, Stefan.
I knew by
related with
inviting
what-
this group that you would contradict everything I say and follow none of my instructions. So don't worry, I'm not surprised.
I'm so sorry. But I just wanted to say something that I think is very interesting regarding what Luis just
Sure.
said. And, you know, related with corruption and transnational corruption or bribery or private bribery, we don't have here for transnational bribery. We do have, sorry, double jeopardy. So non bis in idem. So something really interesting that happened 6 months ago is that the largest bank, one of the largest banks in Colombia, it is a Colombian bank, and that participates in one of the largest infrastructure companies in Colombia, were involved in Odebrecht. So they went to the DOJ, and I'm saying this because this is important maybe for the audience to know. They went to the DOJ and they signed a DPA with the DOJ and with the SEC, the SEC in the Security Exchange Commission in the US. And the funny thing about this is that prior to that, in Colombia, one of the regulators, the Superintendency of Industry, sanctioned that company, that infrastructure company, with a really important fine. So they were challenged this decision in Colombia, but at the same time, they went to the DOJ. So the DOJ said to them, okay, we are going to sign this DPA, but you cannot challenge the decision of the Colombian authority. So you have to accept, and you cannot go to the Court of Appeals, and you cannot challenge, and you are going to accept what Colombian authority is saying to you. So this is something that was like for us. Yeah. For some people said, okay, so the DOJ is trying to get involved in the Colombian legal system. So how are they? But at the end, this worked very well for us. I mean, for the regulator in Colombia, because they didn't have to go to the Court of Appeals to defend their decision. So I just wanted to say that. And related to what Luis was saying with with Mexico, is that it is, when I talk with my clients, like with multinationals, they are always surprised because in Colombia enforces robust regulations in compliance related with anti-money laundering, CFT, ABC programs that applies to almost all types of companies. And those regulations are really strong. So the content of these programs is determined by the supervisory authority and considering a specific criteria for each sector that could be the assets, the incomes, the number of employees, and the corporate purpose. So what I want to say is that compliance programs in Colombia applies to almost all types of company, not only the financial sector. The first one, of course, was the financial sector. But then if you see our regulation, it's really specific. For example, related to a program is almost like a copy-paste of FCPA guidelines. So we do have to have a lot of things related with entertainment policies, gift policies, relationships with public service, public officials, and we do have a strong compliance program for all the company. We do have to have risk assessment matrix related with anti-money laundering, related with anti-corruption, anti-bribery, and we have observed in an increasing level of enforcement by the regulator in the recent months. And so those kind of, because there have been a lot of sanctions for the companies. The sanctions are related, for example, with due diligence internal procedures, KYC procedures, or related with, because of the branch company in Colombia applies the global compliance program of the parent company in Colombia without complying with all the requirements of our regulation here in Colombia. So, or because we have the program in English and the regulations say that all the policies need to be in Spanish. So we do have a really regulation that explains by detail what a company needs to have related with compliance programs. And the enforcement in the last, I will say, 6 months, has been like a lot of sanctions for companies in a lot of ways. And, you know, here in Colombia, companies, I think they're more aware that they need to have compliance programs that comply with Colombian requirements. And those requirements are not the same of other jurisdictions. So there are very specifics. And I think this has changed a little bit in the mind of companies, because sometimes they say, we do have a global program, a compliance program, we do have a compliance department, and things are so specific that, for example, the compliance officer, they need to live in Colombia. So they cannot be outside Colombia. They need to live in Colombia, and they need to have at least 6 months of experience, and they need to show all the training they have, all the certificates they have. So these kind of things, I think we are a little bit more advanced than some other jurisdictions.
This is really micromanagement.
Yeah, exactly. It's micromanagement.
Oh, and it's interesting we tend to think that compliance is one size fits all. If you comply with DOJ requirements, guidelines, then you're good globally. Turns out, well, not so much, at least for Colombia. And I think, very much it depends who you're dealing with in terms of enforcement. And everyone knows how proud the French are. So even if globally overall it's very comparable, you probably want to double check. But I think the amount of detail you've just described to be surprising and a bit worrisome. I would definitely need to double check with you before I take the job of a compliance officer in Colombia. One of the aspects of compliance, of course, is to investigate reports that you get. And obviously, in France and the EU, we have a whistleblower policy. And to address the whistleblower reports, we have to carry out internal investigations. And there's been ample debate as to what is an internal investigation. We've had guidelines from the National Financial Prosecutor, instructions from the Anticorruption Agency, and so on and so forth, and what constitutes, a good or real internal investigation, and what is, whitewashing, as these investigations can sometimes be. And as an ethics, a member of the enforcement board of the Paris Bar, it's sometimes very surprising to see how lawyers are inclined to sign sign off things that they probably shouldn't have or should have done more cautiously. But Fabyola, when it comes to Brazil, how do you deal with internal investigations? How is it perceived? How do you structure it?
Oh, good. It's really nice to hear, Pamela. For sure, my last comment will say we need to learn a lot of things. And Stefan, why we need to learn? Because during the car wash operation, we received a bunch of announcements. So you can imagine that the operation started by money laundering, and then corruption, and then tax evasion, and then fraud, and then started all international agreements, a lot of international cooperation to achieve this result. So all companies start the internal program, the internal it's a complex program or it's not, but it was imposed. Our legislation said, okay, all companies need to create a structure. So I know that you like my next slide. I don't know the other panelists because I love the picture, and I'm sorry if it's not necessarily so polite picture, but it's what we show here in Brazil. So not this one, this one. See it. A lot of behaviors in Brazil. So we started the super nice in compliance team. The focus in the beginning was corruption. So they invest bounds of money. Why? Because corruption, money laundering, equal, wow, we will see a lot of problems in terms of ethics, in terms of image and the company. What do I have? So expensive budgets to invest and increased a lot in the channel of denouncement, moral harassment, sexual harassment, and decrease on the same way what is related to corruption. So we don't have any more task force. The government transferred to the private sector to say, look, you need to investigate. You need to evaluate what was happening inside your company. And in the same way that we transfer this power, we transfer this power to the investigators, to the internal investigators. If the internal investigators come from, for example, the criminal side, maybe they will ask questions. They start to collect evidence first. They don't necessarily pay attention on the evidence. We don't have a rule. We don't have a method that each company needs to follow. So you create whatever is possible internally. So collect evidence, analyze the documents with the discovery phase, and propose questions and select individuals to be interviewed. But who will be the investigator? So in Brazil, we discuss at this moment a lot about the conflict of interest, because when we restart an internal investigation, you have a focus or not. In the beginning, or during a super nice moment or car wash operation, the focus was, wow, we need to be the first to sign a lenience agreement. Now it's internal discussion. It's internal fraud. So how is the purpose? So the investigator can start an investigation, an internal investigation, to protect someone, to fire. So this is our moment. So we don't have so much budget to the investigation. We need to disseminate, that's really important, the chain of custody. The internal investigators, they just collect, prepare a final report that could be really detailed, and this is our recommendation, but not necessarily. And then we need to take care about these documents. We need to protect this information. Why? Because and somehow the labor court can ask you, the criminal court can send another to present the internal investigation, and also sometimes we have cross-border investigation, and we need to present the evidence we collect other countries to other authorities. We need to prove that. So I always discuss here when the client asks me to help with the interviews, how is the purpose? You protect all the evidence. Anyone can ask if we change the information and message, or at least the content of the interview. And this is one question I would like to hear from the other panelists, because when the investigator receives an information, how they treat this information. In Brazil, we are not obliged to present what we received to the authorities. Who decides that? Who keep this information? And we know that in many crisis management, we need to deal with this information. So who will be the guarantor? And more than that, for how many times? So the time that we need to keep this information. And when we think about the angel or the evil, I know that, Stefan, sometimes that when we go to the authorities, we know that in Brazil, the federal prosecutor always will be the devil. every time, all the time. So they always would like to pursue and to convict individuals. When it is internally, and I move to the another topic that I would like to see, the efficient expedition, is that when we collect evidence, my preliminary question is the purpose. And also, we need to conclude and to keep the report. What I see recently is that the people that are the individuals, the directors are fired, start a claim to say, look, they don't conclude the investigation, or what's not good. They present an announcement in Brazil at a company, wait, not so much, and then go to the authorities and say, look, I presented the announcement, an internal announcement, and anything happened. But what is anything happened related to the environment, not specifically related to the corruption? So we changed the scenario now, and we are in the middle that we need to establish more cooperation. So we saw the authorities that really wants to receive a nice, for example, and when I go to the chief of police, they expect that I present a super report.
Right.
Okay, you finish your internal investigation, doctor, lawyer. So please give me all the report, the off desk, and the chain of custody. You protect, you need to prove. And then someone asks, oh, we need the experts to assure if all the contexts you are under legal way. So they expect that. And if you don't provide, maybe the company suffers penalties, sanctions, not only in terms of law, but maybe in terms of the reputability, because the same guy present all these things to the media. We have a superpower in Brazil that called media. So they love it, and the same white gun, they love to produce videos. They love to record this interview. So when someone records this interview without you notice, and oh, it was a coercion. So on the same way that the authorities present and did coercions in Brazil to receive an announcement and to settle an agreement, they did the same. Say, oh, but it was not the true. It was not blah 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 blah. So my question.
It's interesting to see the same problems, you know, all over the place, and the challenges that corporates face in providing evidence, you know, are comparable, and there will be challenges to our work and potential, you know, exposure for us as lawyers doing that. And you know, what I always tell my clients is that the due process, I mean, the documenting what you're doing is always the best shield, because everything you do is going to be challenged and recorded and taped and put in some, you know, Twitter account somewhere. And so this is you know, really interesting. I'll get back to you know, time is flying. I want to this is all fascinating. I want to move to Francisco and then Luis Dantón, and then maybe, you know, each one of you can have a final conclusion. I don't think we'll have time for much more than that once, of course, Francisco and Luis Dantón have spoken. So maybe if we move back to Argentina, you know, what should, you know, lawyers and, you know, companies be aware of when it comes to cross-border investigations involving Argentina?
Yeah, so I wrote down something Pamela said. So it's the one size fit all in compliance. That's a risk in investigations as well. So when we work with other firms, usually U.S. firms with this FCPA problems, a lot of the conversations before launching an investigation here is, what are the pitfalls? What are the things you should be mindful of that might cause problems ahead if you apply the same American approach? So just, I know we're short of time, we'll just, you know, put some stuff out there, but when you're dealing with Argentina, well, it's a country generally known for having very strong labor laws and very employee-friendly courts, and that does have an impact in investigations. So understanding the local culture, when you're interviewing is fundamental. Knowing who's going to be in the room, what language is going to be used. While you can expect employees here to understand English, providing answers on technical, financial, commercial information in another language can be problematic. And you run the risk of leaving information out of the table. The same with taking disciplinary measures. Companies must be very careful to analyze the consequences from an employment law perspective. So the level of proof required in local courts, for example, to substantiate termination for cause, are very different than in other jurisdictions. And sometimes investigation lawyers, they're more interested in establishing causal relationships, just are not able to see what future contingencies on certain recommendations. So that's definitely a very interesting discussion. Other very common issues here are data collection. WhatsApp here is the king of messaging apps. I think I would say 100% of the country is addicted to it. So in a lot of business, in a lot of industries, more business is conducted over WhatsApp than email or text messages. So understanding if your employees have corporate devices, they have bring your own device, that presents different sets of challenges, if you need their consent or not. So these are a lot of interesting questions you want to ask yourself before launching an investigation here. And definitely knowing what sort of, I think, skills you have in your team, because those are definitely been changing in the past few years. I think investigation lawyers are almost obligated to learn data analytics. Now with, you have AI tools, you have technology assisted reviews with different e-discovery platforms. So if you don't understand what the data sets you're reviewing, what are the data points you're looking for, what are your data filtering strategies, that can lead to a more expensive process and less dynamic, less useful for the investigation. So there's definitely a lot of things. I'll keep it brief. I know we were out of time, but we always do recommend to have someone local pitch in. If it's in the interviews to help with the cultural distances, if to have a second level review of the documents, understanding the local culture, if anything, I think it's a great added value when doing cross-border investigations.
That makes complete sense, and clearly, as I mentioned, there are common trends, but there are also local differences, and the weight of understanding analytics tools, as you described, is huge in the balance. And as lawyers, we should definitely understand the tools and stay updated on what it is they can do. Thanks so much, Francisco. I'm going to move to you, Luisa. You have 7 minutes, and then each one of you can speak for 2.
Thank you, Stefan. I'll make mine all of the comments on pitfalls that Francisco brilliantly explained, and we'll pick up with his last comment on artificial intelligence. I think, and I'm seeing in my practice how it is changing the way we do investigations. Perhaps the major investigation that we all have in mind related to Mexico is the 2011, 2016-17 investigation of Walmart. And there was a kind of turn every stone investigation, boil the sea investigation, where thousands of documents were reviewed, spanning the entire company in a very large period of time. You wouldn't see an investigation like that now. I think artificial intelligence has narrowed the scope of the things that you get to review from a document perspective. And that's a big game changer of the way law firms approach investigations. If these large investigations come every certain number of years, are hard to come by, now they will be more narrowed, and I think that's what we're seeing. And we're seeing an uptick in investigations in Mexico because our vicinity with the US makes the risk of not investigating and having a world-class program in Mexico very high. So for French companies or companies from abroad doing business in Mexico, I would say European companies, they need to be mindful that the risk of not conducting investigations, having in mind the European or the American standard, can be a risky proposition. We need to be thinking that this is going to be scrutinized according to the highest standard in the jurisdictions that we are doing business with. So to look at Mexico and forget that our vicinity makes us a high risk in terms of compliance in itself because of local corruption, and to forget that because of our vicinity with the US, cooperation will likely be strong in the next cases that we will see, would be something that I think would be an unacceptable risk. We need to look at investigations in Mexico, and that's what I'm seeing in my practice, being conducted very carefully with international counsel cooperating and analyzing the issues that Francisco summarized. That would be that for me.
Excellent. Thanks. Thanks so much, Luis. Maybe we go for a last comment, a short comment from each one of you, and if we have time, maybe a couple of questions. The issue, Pamela, if I go to you, we've spoken about the investigations, the compliance, the obligations, the legal constraints. One of the key issues in our cross-border enforcement world is the pros and cons of self-disclosure. Is it relevant? What are the risks? We've heard about the lack of double jeopardy, which is the same in France, by the way. You have double jeopardy if it's a decision within the European Union or the countries that are under the European Convention on Human Rights. So it's beyond the European Union, but beyond that, you would have no recognition of foreign judgment in terms of of double jeopardy concern. So pros and cons, Pamela, for self-reporting.
I think we do have some leniency programs in Colombia. One related with antitrust practices and other one related with transnational bribery. But at the end, I think we don't have a lot of hands-on experience. I mean, the regulator, they don't have a lot of hands-on experience. And this also, I think another problem is that companies, they don't want to. They don't want to because they don't know what to expect, So sometimes the first question that a company, when it comes to us, ask is, are we obliged to self-disclose? So is this kind of crimes or felony that we need to self-disclose? So, and here in Colombia, there is a crime, and a specific crime for some crimes that when you don't go to the authorities and you don't self-disclose, you are committing that crime. It's an omission of not disclose some information that you have related with a crime. But it only applies with some kind of offenses, like anti-money laundering, like, for example, not corruption. That's funny, not corruption, human with our life crimes or something related with that, but not corruption. So at the end, I think the company, what they do is they try to see, okay, if I go to the authority, first question is, which authority? The General Attorney Office that I think is the same thing that Fabyola said before with Brazil, or I go with the regulator, bearing in mind that we don't have criminal liability for companies. So where we go? So maybe the first choice to the company is I'm going to protect myself and I'm going to go to the regulator, to the superintendency. So I'm going to try to get all the information that I can have. So I will have an internal investigation, or I will hire an external investigation, and I will give this information to the authority. Then you have to do it before the authority realize that something is happening, you know? So then the companies start to think, okay, so is going the authority to be able to get to this point of my company and realize that there is something wrong? And also you have to bear in mind that in Colombia, the major scandal of corruption, and not even the major, most of the scandal of corruption, they were discovered by the medias. So they were not even discovered by the authorities. The authorities, they always get after the medias, after the news, after the scandal goes to the news. So the pros, I will say, is that if you do an internal investigation or an external investigation and you have everything to share, all the information, all the proof to share with the authority, you could have some partial immunity or a total immunity, but it will depend in the person of the public official that is going to handle your case. So if they consider that the information is accurate and it's good information and it has been delivered on time, so maybe you will have a total immunity, or maybe they will have a partial immunity, or maybe you will have that and you will give all the information to them so they can begin a process.
Okay, that's loud and clear. And you know, and it's also one of the issues that was raised by Luis early on Mexico. You know, very much an issue of knowing who the other person is, and sometimes it feels like the lottery. And I think we're very fortunate, at least in France, that we have a sort of a central PNF that will deal with the cross-border matters. But you know, speaking from one prosecutor to another, they're of course different human beings, and they can have different views on the situation. So it's there's communications, there are guidelines, but it's also an issue of you know, getting to convince who it is you're talking to. Fabiola, in a couple of minutes, what's next in anti-corruption in Brazil? You've shook the whatever it was with these massive investigations. What's next?
1 minute.
In 1
not
minute,
much,
yes.
not much to add to your comments. So exactly same in Brazil. But thinking about the future, thinking about this year, we don't have any more government enforcement at this moment, like Francisco mentioned. So we are just waiting. Imagine that the president some years ago was in jail, so now it's our president. So it's a problem. But so my perspective is we need to cooperate. We need to join public and private. We need to create manuals. We need to create internal procedures, not just internal, but we need to put the public prosecutor and the regulator and the judiciary system together, plus the private sector, and then maybe construct something that we can, okay, we have a standard evaluation of evidence. This could be a good solution in terms of when the company presents us a fact, and definitely, Pamela, we don't know what to do. So maybe that we always say, oh, the decision is for the administrators, but internally we don't know, because we don't really trust and we don't see it's not safe in terms of what the results. So we present this document, we don't know how they will evaluate, they call the pressure, and we don't know the results. So we need to do more. Maybe Stefan, you can help us, but we need to do more.
Yeah, but it's interesting to see how in each of our jurisdictions, you know, we have the similar comparable problems, and it's an issue. It burns down to the individuals involved and how committed they are, and how they can team up, sometimes with the press, sometimes with the university professors and with colleagues globally. What's your last 2-minute comments on that, and then we'll go to Francisco for his input on the first DPA under the Argentine corporate criminal law.
Thank you, Stefan. Sunday, Mexico will have a presidential election, and I think that the future will be influenced by this election. We know that anti-corruption enforcement always has a big political component. We've seen that in Brazil, we've seen that in Argentina, and in Mexico, I think that if the result is a continuation of the political party that is currently ruling Mexico, and they get a very strong showing at the polls, we will not see a big difference in the willingness of power to investigate itself. This government that is finishing is finishing with scandals of corruption that rival any scandal of the past. However, I think the wild card and the important thing that we have is the external factor, which is the activity, the cooperation with the Department of Justice. And I think we will reach, notwithstanding the elections, the 10th anniversary of our new system with an important case of international cooperation. That is my prediction. So I am optimistic that we continue to make progress, and despite the political complexities, this is not a fad. This is something that has come to stay, and companies are mindful of that, and they keep investing in compliance programs and in conducting investigations.
Excellent. So we'll hear more, and good luck with the election. This is the year of elections, 2024. I think it's the most elections that we've had globally in possibly forever. So good luck there. Francisco, to you, maybe for your final words on thoughts maybe on the DPA, because that's what's new and is not going to disappear, certainly not in France at least, or other closing remarks you'd like to say.
Right. So on the DPA, it's interesting. There's a lot of things to analyze. So the agreement was signed in 2022. It's still confidential, but recently a lot of facts were disclosed by the media as several individuals were arrested. So we know that almost 20 people were arrested. The case basically, in a nutshell, a private security company paid bribes to several public entities, union leaders, and government-owned companies to obtain or secure business. Nothing new there. The amount of bribes was significant. It was around $8 million. So some of the things I'm interested, and hopefully we'll know more as the agreement is made public. We know that as part of the agreement, the company was forced to pay outstanding tax debt for almost $2 million. They had to buy produce, believe it or not, for local communities as remediation actions, about 1,000 kilos of meat and for local schools. And obviously they had to implement a lot of enhancements to its compliance program. So it's definitely not your typical DPA where you only see a big fine, but there are a lot of, I would say, alternative means of remediation, such as, working community remediation or paying tax debt. So that's interesting. It's interesting to say that will stay on as a trend, or if it was just how that negotiation went. And also that the agreement includes bribes paid to public official and union leaders, which are private, at least for local laws, that's commercial bribery, which is not, it's not punished under local legislation. So that's interesting to see how that sort of got into the agreement and why payments to union leaders are being punished under this law. So there's a lot of things to keep a look at, and hopefully when this is made public, we'll know more.
Excellent. Thank you so much. And maybe for another discussion, the question of private corruption is an interesting one. We do have the public and private one in France, and the reasons for that are also interesting. I just want to say a big thank you to all four of you for joining this conference, for preparing, for answering candidly. It certainly was a superb learning experience on my end, and I definitely hope we can work further on these issues, and I've noted the need for exchanging amongst the members of the legal community globally. So thanks so much. Thank you to the Ministère des Affaires étrangères and la Semaine de l'Amérique latine, and see you all and the rest of you soon. Take care.
Thank you.
you.
Thank you.
Nice to
Bye.
find
Thank you.
Bye.
Bye-bye.